My name is Jesus Maria Alvarado Andrade. I am the director of the graduate school at Universidad Francisco Marroquín and president and founder of the UFM Law Liberty Circle. In this presentation of today's activity, which is essentially a book club session through in a more formal setting, I would like to recall that the UFM Law Liberty Circle began in 2024 with the signing of a memorandum of understanding with the International Law Liberty Society. Our purpose is to create spaces for intellectual discussion on the importance of law and the principle of the rule of law among students, lawyers, law professors, and judges. In 2024, on the eve of the centennial of Manuel Ayau, founder of the Universidad Francisco Marroquín, which we are celebrating this year, we deem it essential to deepen our understanding of the legal principles that underpin a society of free and responsible individuals, a fundamental part of the mission statement of the University Francisco Marroquín. For that purpose, we consider it too appropriate to strengthen our ties with like-minded organizations such as International Law and Liberty Society and the Federalist Society, especially given that our undistinguished founder maintained close relationship with leading conservative and libertarian institutions, including the Heritage Foundation, the Foundation for Economic Education, the Hoover Institution, Hillsdale College, the American Enterprise Institute, Liberty Fund, the Cato Institute, and the Independent Institute. Thus, our relationship with the International Law and Liberty Society and the Federalist Society was both natural and particularly significant in the legal realm for foundational reasons and others, as I shall mention later. As the UFM Law and Liberty Circle, in alignment with the ideals of Universidad Francisco Marroquín and the principles of both the International Law and Liberty Society and the Federalist Society, we seek to critically examine Guatemala's legal order, inspiring similar initiatives across the region, and above all, to uphold the idea of a free society which can only exist under true separation of powers and holding authorities accountable through a judiciary committed to the Constitution. In the face of legal progressivism, we emphasize that judges must apply the law as it is, not as they think it ought to be. In Latin America, the issue is particularly complex as progressive ideas we have gained increasing prominence. Unlike the United States, where the originalist debate has spurred a revival of classical constitutionalism, our region not consolidated. The recovery of constitutional government requires not only normative reform, but also a sustained intellectual effort to understand the Constitution. The UFM Law and Liberty Circle, especially the book club, was conceived precisely an academic forum for critical reading and reflection on foundational legal works in dialogue with the tradition of classical liberal constitutionalism. For this reason, in the circle initial months, we have to choose to study the Meese Revolution, the making a constitutional movement, written by Steven Gow Calabresi and Gary Lawson, two distinguished American jurists, widely read by those who value constitutional and administrative law. We believe, Professor Calabresi, the choice of the first book was especially fitting. First, because next year marks the 250th anniversary of the Declaration of Independence of the United States, a milestone with profound influence on Western political and legal thought. Second, because our relationship with the International Law and Liberty Society and the Federalist Society call on us to deepen our study of originalism and its development in the American constitutionalism. Third, because the centennial of Manuel Ayau reminds us that he was, in a sense, a pre-originalist who emphasized the importance of the original intent in constitutional interpretation. And fourth, because Ed Meese, a central figure in your book, was a doctor honoris causa awarded in 1989 in Francisco Marroquín University. Over several months, we have discussed this book in an open space for students, professors, and scholars with a valuable intervention that have enriched our dialogue. A pleasant surprise and a great honor for this club and for UFM Law Liberty Circle has that one of the authors accept our invitation to join us from the United States. Professor Steven Calabresi, who's seen on the screen, is the Clayton and Henry Barber Professor of Law at Northwestern Pritzker School of Law. He has also been a visitor professor at Yale Law School, the prestigious university from which he graduated, and a visiting professor of political theory of Brown University. He's also the co-founder and co-chairman of the board of Federalist Society, and he worked in the White House under President Ronald Reagan, served as a special assistant to Attorney General Ed Meese, and clerk for Anthony Justice Scalia at the USM Supreme Court, as well as for judges Robert Bork and Ralph Winter and the Federal Court of Appeals. He has published over 70 law review articles and essays, and authored an important books, and as an example, The History and Growth of Judicial Review, an important casebook, The USA Constitution, Creation, Reconstruction, the Progressives and the Modern Era, an extraordinary casebook whose new edition I hope to buy it. And another, The Unitary Executive Presidential Power from Washington to Bush. Professor Calabresi has taught constitutional law, comparative constitutional law, federal jurisdiction, administrative law, and as I mentioned, he's the co-chairman of the Federalist Society. I sincerely believe that he has the ideal profile to serve as a justice of the USM Supreme Court. However, at this moment, it's an honor to have him with us, and we look forward to welcome him in person in Guatemala on a future occasion. For a fair, please receive our deepest gratitude from Guatemala, and the floor is yours. Thank you so much.
Thank you so much for that incredibly gracious introduction. I am so proud to be able to talk to your chapter today about my recent biography of Attorney General Ed Meese. And I'm thrilled to hear of the formation of your chapter and of your efforts in Guatemala and in other parts of Latin America to promote the rule of law. As you said in your introduction to me, a society can only prosper if it has a free economy, property rights, and if judges follow the law and don't make it up. And that this is a constant struggle that every generation must fight to win. It's the temptation for judges to make up constitutional law is a great one. And we've struggled with it in the United States. And for the moment, at least, we seem to be winning in the United States. But I'm well aware that in many countries in the world, the situation is different. And even here in the United States, we have 3 out of 9 justices on our Supreme Court who would make up the law rather than following it. So I want to tell you the story of Attorney General Ed Meese, who I worked for, who was the right-hand man to President Ronald Reagan, who's on the left-hand side of your screen. President Reagan was president of the United States from 1981 to 1989, and he was, in my view, the most influential and consequential president of my lifetime, and one of the 3 greatest presidents of the United States, along with George Washington and Abraham Lincoln. Ed Meese was his right-hand man in everything he did, and also his chief legal policy advisor. And President Reagan believed very strongly in appointing judges who would follow the law, not make it up. And he knew that he could trust Ed Meese to do that. Ed Meese went on to become Attorney General under President Reagan from 1985 to 1988. And during those 3.5 years, he was the most influential and consequential Attorney General in American history. And so understanding his story is understanding how the United States came to follow to a Supreme Court that now follows the law rather than making it up. Whereas when Ed Meese was taking over as Attorney General in 1985, the Supreme Court was still making up the law. So the question naturally arises, why is it that Ed Meese was the most influential and consequential Attorney General in American history, and also the best Attorney General in American history? And American history stems back 236 years continuously under the Constitution. And there have been 87 attorney generals. And so to argue that Ed Meese is the best attorney general is to make a significant claim. There are several reasons why Meese was so influential in restoring the rule of law and getting the courts to follow the law and not make it up. First, he's the only attorney general in American history who put forward a theory of judging and a theory of interpretation. And his theory of judging and of interpretation was called originalism. And he argued that judges should follow the original meaning of legal texts and put them into effect and not make policy decisions. A second reason why Meese was so influential, aside from being the only attorney general to put forward a theory of judging and of interpretation, is that he was President Ronald Reagan's right-hand man, and Reagan was a transformative two-term president who won the Cold War with Ed Meese's help. And then finally, Meese was so influential because of the longevity of his activities. From 1981, when President Reagan became president and started relying on Ed Meese to pick justices of the Supreme Court, to 2025, Ed Meese has remained involved in debates about judicial policy. And I actually just spoke with him on the phone 2 days ago because he's signing a brief that I'm filing in the Supreme Court on a particularly influential issue that's before the Supreme Court. So what I'm offering you is a description of American legal history from 1981 to 2025, and not a policy account of American legal history. These are photographs of 4 Supreme Court justices who Meese helped to pick without serious interference. And they are clockwise: Chief Justice John Roberts, who's now the Chief Justice of the Supreme Court. To his right on the top is Justice Antonin Scalia, who served from 1986 on the Supreme Court until his death in 2016, and who is a major force for originalism. On the bottom left is Justice Samuel Alito, who Ed Meese urged President George W. Bush to appoint to the Supreme Court. And at the bottom on the right is Chief Justice William Rehnquist, who Ed Meese persuaded President Reagan to appoint. Chief Justice Roberts and Justice Scalia agree 90% of the time. And that's significant because some in the American press like to argue that our Supreme Court justices disagree with each other a lot. But in fact, the people who Meese put on the Supreme Court agree with each other far more often than not. Another prominent attorney general in American history who one could compare Meese to is Attorney General Homer Cummings, who was Attorney General to President Franklin Roosevelt. Homer Cummings picked 4 justices for the Supreme Court: Hugo Black on the left, Stanley Reed to his right, William O. Douglas to his right, and then Felix Frankfurter on the far right. And these justices all disagreed with one another once they were on the court. They went in all different directions, whereas the justices who Meese picked went in the same direction. Another great attorney general in American history is Robert F. Kennedy, who was attorney general to his brother, President John Kennedy. Robert F. Kennedy oversaw the appointment of 2 justices to the Supreme Court, Byron White, who was a conservative, and Arthur Goldberg, who was a radical left-wing liberal, and they canceled each other's votes out. Meese's justices didn't do that. So how is it that Meese transformed constitutional law via originalism? He did it in a number of ways. He did it by giving path-breaking speeches, which got a great deal of press attention. He did it by making judicial appointments, appointing judges who would follow the law, not make it. His attorney general issued monographs, and his Justice Department issued monographs and opinions based on the original meaning of the Constitution, and he filed originalist briefs in the Supreme Court. Meese first announced his commitment to originalism on July 9th, 1985, in a speech to the American Bar Association. And in that speech, he shocked the American Bar Association by giving the Supreme Court low grades on its 1984-1985 term of court, which it had just completed. Former law professor and now Attorney General Ed Meese gave the court an F on federalism because of its pro-national power ruling in a case called Garcia against San Antonio Metropolitan Transit Authority. And he also gave the court an F for its Establishment Clause religion cases. But most importantly, he announced that it has been and will continue to be the policy of this administration to press for a jurisprudence of original intention. In the cases we file and those we join as amicus, we will endeavor to resurrect the original meaning of constitutional provisions and statutes as the only reliable guide for judgment. To the extent possible in 1985 to 1988, Attorney General Meese urged the appointment of only originalist judges. That speech to the American Bar Association was the first of more than 40 historic speeches, and he also gave important speeches on constitutional interpretation to the Washington, D.C. chapter of the Federalist Society, replying to 2 Supreme Court justices who criticized his July 9th, 1985 ABA speech. He gave an important speech on federalism and decentralization on September 6, 1985. On February 27th, 1986, he gave an important speech on the separation of powers, calling for the overruling of Humphrey's executor and denouncing the constitutionality of independent agencies. And then on October 21st, 1986, he gave an important speech on constitutional interpretation, yet again, this time to the Tulane chapter of the Federalist Society. His Office of Legal Counsel issued an opinion advising President Reagan to veto a bill creating a national lottery because Congress has no enumerated power to create a national lottery. He urged the veto of a bill that would have codified something called the Fairness Doctrine, which impaired free speech. And in the wake of his veto, the Federal Communications Commission, the FCC, repealed the Fairness Doctrine. And in general, he urged overruling on originalist grounds. Many cases that 35 years later have in fact been overruled. So we had a case that established a right to abortion, Roe v. Wade. Ed Meese urged that that case be overruled, and it was overruled in 2022 in a case called Dobbs against Jackson Women's Health Center. Ed Meese criticized the Supreme Court's case law as being hostile to a religion. Today, the Supreme Court's case law is very supportive of religion and of religious liberty. Ed Meese criticized two cases, Mapp against Ohio and Miranda against Arizona, which allowed for the exclusion of evidence of guilt in criminal trials. Those cases have since been broadly chipped back. Ed Meese criticized the broadest New Deal federalism cases, and those cases have been cut back. Ed Meese called for overruling Humphrey's executor, and the Supreme Court is expected to do that this term. And in general, he urged for a radical reconsideration of American constitutional law. Ed Meese's impact on constitutional law came in part because he was the first originalist. There were three people who played a role in starting originalism: Ed Meese, Antonin Scalia, and Robert Bork. But Meese was the person who spoke out about it first. And proof of that can be found if you look at electronic databases of mentions of originalism, originalist, and original meaning. And one finds that after Meese's tenure as Attorney General, there are thousands of references to those terms. But before his tenure as Attorney General, there were only 9 references to those terms between 1980 and 1984. And prior to 1980, there were no references to the term. Another database of law review and articles shows that, again, prior to 1980, with Ed Meese, there were no references to originalism. The policy goals of the professoriate in 1985, who Ed Meese was fighting back against, were to create a constitutional right to welfare and to hold the death penalty to be always unconstitutional. Ed Meese managed to stop that from happening. This is the Supreme Court that Ed Meese inherited when he became Attorney General, and not a single justice on this Supreme Court in 1985 was an originalist or a believer in the rule of law. They all believed judges should make up the law. This is a photograph of the U.S. Supreme Court today, and 6 of these 9 justices are committed to the idea that the court should follow the law and not make it up. And 6 out of 9 justices are very firmly committed to that idea. How did Ed Meese turn his speeches into constitutional law? Well, first was with judicial appointments. He persuaded his friend, President Reagan, to nominate William Rehnquist to be Chief Justice of the United States and to nominate Antonin Scalia to be an Associate Justice of the Supreme Court of the United States. And both Rehnquist and Scalia became powerful advocates for the rule of law and the idea that judges should follow the law, not make it up. In doing this, President Reagan replaced the second most conservative member of the Supreme Court, Chief Justice Warren Burger, whose photograph is on the left, with William Rehnquist, who was well to Burger's right, and with Scalia to fill the vacancy that Rehnquist had held, and Scalia was well to the right of Rehnquist. Attorney General Meese also persuaded President Reagan to nominate Judge Robert Bork to the Supreme Court. And then when Bork wasn't confirmed, he persuaded the Senate to confirm Justice Anthony Kennedy to the Supreme Court, and Kennedy issued many originalist opinions. Ronald Reagan as president and Ed Meese as attorney general created a farm team of people in lower level positions who later went on to serve on the Supreme Court. Professor Antonin Scalia was made a lower court judge before he was elevated to the Supreme Court, and his photograph as a lower federal court judge appears on the left-hand side of the screen. John Roberts, on the top right-hand side of the screen, served in the White House counsel's office under President Reagan and became friends with Ed Meese. Clarence Thomas, in the middle of the screen, worked in the Reagan administration as the chairman of the Equal Employment Opportunity Commission. And Sam Alito, who's currently a Supreme Court justice, worked in Ed Meese's Justice Department, writing legal opinions. So all four of these individuals held lower level positions in the Reagan administration that put them in a place where they could ultimately be named to the Supreme Court. One thing about Meese's revolution in transforming the American judiciary was its intellectualism. He appointed an extraordinary number of law professors who became judges. So just to go over the names of these people, the people on the screen, some of which may mean something to you and some of which may not. He appointed on the left, top left, Robert Bork from Yale Law School. Next to Bork, he appointed Antonin Scalia from the University of Chicago Law School. Next to Scalia, on the top in the middle, he appointed Ralph Winter of Yale Law School. Next to Winter, he appointed Richard Posner of the University of Chicago Law School. And all the other judges on the screen were law professors who he appointed judges. Usually, law professors are not appointed judges in the United States. So as a measure of the intellectualism of Meese's attorney generalship that he appointed the judges he did. Ed Meese transformed the U.S. Court of Appeals for the District of Columbia Circuit, which is the second highest court in the country, giving it a solid rule of law majority. He appointed 5 very distinguished members to that court: Lawrence Silberman in the upper left-hand corner, Jim Buckley in the middle on the top, Professor Stephen Williams on the top right, Professor Doug Ginsburg of Harvard on the bottom left, and Judge David Santel, a district court judge from North Carolina, in the bottom right. Another thing that made the Meese Revolution so impactful was its length. As I said, it began in 1981 when he was an aide to President Reagan, and has continued to the present day when just 2 days ago he agreed to sign a brief that I'd written in a case before the Supreme Court this year. One thing that is often not known about Ed Meese is that he was very good friends with Reagan's vice president, George Herbert Walker Bush, who's in the middle of this screen. And he encouraged Vice President Bush to hire a White House counsel, a White House lawyer, C. Boyden Gray, who's shaking hands with President Reagan on the left-hand side of the screen, who was put in charge of judicial selection for President Bush. And then he also encouraged President Bush to appoint Richard Thornburgh, who's on the right-hand side of the screen, to be his successor as Attorney General. And the unknown deep ties that Ed Meese had to President George H.W. Bush allowed him to continue to play a role in picking judges during Bush's presidency for 4 years after Reagan's 8 years. President George H.W. Bush's instructions to his new White House counsel, C. Boyden Gray, were first to keep judicial selection going for the next 4 years, exactly the way it's been going on under Ed Meese. And Lee Liberman Otis, who was an alumna of the Meese Justice Department, was hired to make judicial appointments, and she saw to it that President Bush Sr. appointed solid rule of law conservatives to the Supreme Court. President Bush Sr. appointed Justice Clarence Thomas to the Supreme Court. Justice Thomas is today the longest serving justice on the court, and he is arguably the most conservative justice on the court. He is also a brilliant scholar and a brilliant originalist and an extremely kind and thoughtful human being. Then, during the presidency of the senior President Bush's son, President George W. Bush, the second President Bush, didn't know much about law, and he wanted to appoint two lawyer friends of his from Texas, Alberto Gonzalez and Harriet Miers, to the Supreme Court. But conservatives opposed that because Alberto Gonzalez and Harriet Miers had no known position on following the law rather than making it up. Bush fretted about this with his White House Chief of Staff, Andrew Card, who's in this picture to the right of the junior President Bush. And Andrew Card met with Ed Meese, and Ed Meese and Leonard Leo gave the Bush Jr. administration the names of four judges who would be acceptable Supreme Court nominees: John Roberts, Sam Ludig, Mike Ludig, and Michael McConnell. Well, the first two names on the list got appointed to the Supreme Court. And so here are George W. Bush's Supreme Court nominees: Chief Justice Roberts, who continues to serve today, and Justice Alito, who is arguably the second most conservative justice on the Supreme Court today after Clarence Thomas. So you see Meese's impact extending beyond Reagan's presidency into the presidency of President Bush Sr. and then into the presidency of President Bush Jr. But Meese didn't stop there. He attended Federalist Society events in Washington, D.C., and at those events, he befriended Don McGahn in the 1990s when he was a law student. And Don McGahn went on to make judicial selection for President Donald Trump during President Trump's first term in office. As things worked out, the Trump Supreme Court appointees who Meese helped to recommend, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, have all turned out to be committed to the notion that judges should follow the law and not make it. So the net result were huge changes in American case law. And I'm not going to describe these American cases to you because that would take too long. But suffice it to say that they were so momentous that they constitute what American constitutional law professors call a constitutional moment, i.e., a moment when the Supreme Court decisively changes course. And that became most clear in 2022 when, in Dobbs against Jackson Women's Health Center, the pro-abortion Roe v. Wade case was overruled. Throughout all of this, Meese was Ronald Reagan's right-hand man, and he was the person Reagan relied on for virtually every task at hand. Attorney General Cummings, who was a very influential attorney general, was not President Franklin Roosevelt's right-hand man. His biggest accomplishment, other than serving as attorney general, was to issue the federal rules of civil procedure and of criminal procedure. President Kennedy did rely on his brother, Robert F. Kennedy, as his right-hand man. And in fact, Robert Kennedy helped President Kennedy defuse the Cuban Missile Crisis, and he also fought for civil rights. But he didn't have the impact that Ed Meese had, in part because his brother was assassinated after 3 years, and so he just served a much less long time. Whereas Ed Meese worked on picking judges from 1981 down to the present in 2025, Robert F. Kennedy was only in office for 4 years. Meese first met Ronald Reagan when he was elected governor, and Governor Reagan hired him immediately to be his legal affairs advisor. He ultimately became Governor Reagan's chief of staff, and this is a picture of Governor Reagan with Ed Meese as chief of staff in 1969. Governor Reagan was the governor of the state of California, which is the most populous state in the country and politically one of the most important. And Meese was Reagan's right-hand man during the time he was governor, as well as when Reagan became president. When Ronald Reagan ran for president, Ed Meese was the chief of staff of his campaign, and Ed Meese also picked his campaign chairman, William Casey, who went on to head the Central Intelligence Agency. And so Reagan was relying very heavily on Meese to get himself elected president. And frankly, Meese deserves a lot of the credit for Reagan winning the presidency. One big decision the presidential candidate Ronald Reagan had to make was who to pick to be his vice presidential running mate. And Ed Meese played a decisive role in urging Ronald Reagan to pick Vice President George H.W. Bush. There were at least 4 other people considered for the job. There was George Bush, a senator named Robert Dole, another senator named Howard Baker, and former President Gerald Ford. But the people in the hotel room making the decision on who to pick were Governor Reagan, Ed Meese, and then 3 people, all of whom were close allies of Ed Meese: Richard Worthland, the campaign pollster; Bill Casey, who Meese had gotten hired as campaign chairman, and Richard Allen, a foreign policy aide who was a close Meese ally. The net result of Reagan's choice and Meese's advice is that after Reagan left the White House, we got 4 years of George H.W. Bush. And then after 2 terms of Bill Clinton, we got 8 years of George W. Bush. So Meese was hugely consequential, even outside of law and even outside of changing the Supreme Court, because he really is responsible for the 2 Bush presidencies. If he had given Reagan different advice on picking a running mate, those Bush presidencies would probably not have happened. Once Reagan won the election, he put Meese in charge of his transition team, and Meese, as chairman of the transition team, picked the members of President Reagan's first cabinet together with President Reagan. And it was a very distinguished cabinet with a lot of leading conservative figures, and Meese deserved a lot of credit for it. Meese was given the title counselor to the president, and he was made a member of the cabinet, and he participated in all of Reagan's decisions. Meese served in the White House as counselor to President Reagan from 1981 till 1985, when he became Attorney General. And during that period, he was President Ronald Reagan's chief policy advisor, and he was a cabinet member. And just to illustrate what an important role Ed Meese played for President Reagan, at the end of a cabinet meeting that might have gone on for 2 or 3 hours, Reagan would ask Meese to summarize what decisions had been made and what decisions President Reagan still had to make. And Meese always did those summaries and was expertly good at them. The power to summarize what decisions have been made in a cabinet meeting of more than 20 people is a very important power indeed. During the time Meese was counselor to President Reagan, he was also assisted by White House Chief of Staff Jim Baker on the left, and by Baker's Deputy Chief of Staff, Michael Deaver, on Meese's right. A myth grew up that this troika of aides were running the White House, but in fact, it was Meese who had Reagan's ear, not Jim Baker and not Michael Deaver. Throughout the 8 years of Reagan's presidency, Ed Meese was always a member of the National Security Council. And so he played a leading role in foreign policy for Reagan, as well as in domestic policy. One of the people who was a rival of Meese, Jim Baker, tried to become National Security Advisor after Bill Clark, who had been the National Security Advisor, resigned to become Secretary of the Interior. Meese basically stopped that attempt and prevented Jim Baker from becoming National Security Advisor. In general, a close aide who worked with Meese on the National Security Council said that whenever Ed Meese disagreed with Secretary of State George Shultz or Secretary of the Treasury by then, Jim Baker, Ronald Reagan always sided with Meese on a foreign policy question and not with his Secretary of State or his Secretary of the Treasury. Early in his term, President Reagan fired some striking air traffic controllers. Ed Meese was very closely involved in the making of that decision. Ed Meese was on the White House Judicial Selection Committee during Reagan's first term and playing an active role in picking judges during Reagan's first term. Ed Meese helped President Reagan develop his Strategic Defense Initiative, which was Reagan's brilliant idea to create missiles that could intercept incoming attacking missiles. And Reagan's Strategic Defense Initiative led to the creation of the Patriot missile systems, which today defend Kiev in Ukraine and Tel Aviv in Israel. And Meese was critical to President Reagan being able to pursue that policy. He also supervised domestic policy for President Reagan in his second term. And then finally, when Reagan's second White House chief of staff had to resign, Reagan called Meese, who was giving a speech in Arizona, and said, "Ed, I need you to come to Washington to help me hire a new White House chief of staff." And Meese said, "I'd love to, Mr. President, but I'm in Phoenix, Arizona, giving a speech." And President Reagan said, "Never mind, I'm going to dispatch a military jet to pick you up and bring you to Washington." And that's precisely what happened. And Meese found Howard Baker, who was Reagan's third White House chief of staff, and who did an excellent job in that effort. As a result of Meese's staunch conservative defense policy, President Reagan was able to win the Cold War. And that victory became clear after President Reagan's speech at the Brandenburg Gate in Berlin, when he urged the Soviet Union's leader to come and come to this gate, to open this gate, to tear down this wall. And then you can see in the map on the right-hand side of the screen the expansion of free countries in Western Europe. As a result of Reagan's tax cuts, which Meese helped to produce, the U.S. economy grew very quickly during Reagan's tenure as president. And this graph shows the increase in U.S. GDP per capita during the 8 years of the Reagan presidency. So the Reagan-Meese legacy after 37 years is the U.S. Supreme Court today, which, as I say, has 6 justices on it who are committed to following the rule of law and not making the law up. And in contrast, 37 years after Attorney General Homer Cummings was serving, there was only one justice on the Supreme Court who followed his legacy. President Kennedy was aided by Attorney General Robert F. Kennedy, but 37 years after Robert F. Kennedy was Attorney General, there were no justices on the Supreme Court who followed his legacy. So in sum, Ed Meese transformed the U.S. Supreme Court into an institution that would follow the law, not make it. And President Trump recognized this by conferring the Medal of Freedom on Ed Meese on October 8th, 2019. The Medal of Freedom is the highest civilian honor that anyone can be awarded in American history. So thank you. I'm afraid I've gone on for probably too long. I've told you about both Meese's efforts to turn the courts into courts, turn the U.S. courts into courts that follow the law and don't make it, and also his role as Reagan's right-hand man and chief policy advisor. But I am now happy to answer questions or hear your comments or suggestions on any of the slides that I showed.
Thank you so much, Professor. Great talk. We have a lot of members of the UFM Law Liberty Circle and questions or comments. You have? Yes, I like to say that I think you've launched a Calabresi revolution here.
Well, you're kind to call it that, but I was just a 27, 28, and 29-year-old staffer to Ed Meese and Ronald Reagan when they did these things, and it was the privilege and honor of my career to be able to work for them in those posts. I didn't, nothing I've done since working for President Reagan and Attorney General Meese compares in magnitude with the pleasure and the gratification and the ability to affect politics that I was able to have thanks to Attorney General Meese and to President Reagan.
Thank you. I also met that through your book. Obviously, we've been enjoying your book.
Very much so. And in our book club, and we've, as you can imagine, we've been talking about how does the American experience applies to the Guatemalan experience.
Yes.
And so as we are reading your book, we're continuously thinking, how could this apply to us? And I think it has been really interesting to think that we have an older sister in the North. I think that we have discovered traditions that are similar in our cultures. Yet in our own constitution, there's many social and collectivist clauses. So how would you apply originalism to a constitution that is such a mixture of liberal rights, proper rights, and at the same time social and collectivist clauses?
That's a really good question, and it's a question that Justice Antonin Scalia, who I clerked for, wrestled with. And what he concluded is that under the separation of powers, the courts have the judicial power, which is the power to say what the law is, not what it ought to be. And in enforcing classical liberal rights, it's possible for judges to do that because they can say that something is protected freedom of expression or protected freedom of religion. It just isn't possible for a judge to enforce a right to free health care, for example, or a right to adequate welfare benefits. The ability to provide positive rights in a constitution, those are clauses that are really addressed to the legislature and to the executive branch and not to the courts, because the judicial power is only the power to interpret the text and apply it. It doesn't include the power to impose taxes to pay for social programs, and it doesn't include the power to specify what is adequate health care and what is inadequate health care, or what is a meaningful wage job or not a meaningful wage job. So I wouldn't say that the clauses enforcing socialism in the Guatemalan Constitution don't mean anything, but I think that they speak to the legislature and the executive in Guatemala, and it's the clauses that protect freedom of expression, freedom of religion, freedom from unreasonable searches and seizures, which have a definite meaning that judges are able to positively enforce. I know it's not satisfying to say that there are clauses in a constitution which a court can't enforce, but that's true of the U.S. Constitution too. The U.S. Constitution includes the power to tax and spend to promote the general welfare. But the U.S. Supreme Court has always held that it doesn't have the power to enforce that clause. That's a clause that's directed to Congress and to the president. So this may be sort of a long answer to your question, and I'm not sure if it's a wholly satisfying answer, but I think it is just in the nature of liberties from government that courts can enforce them, whereas entitlements to money from government requires a power of taxation and a power of setting budgets that is simply not part of the judicial power, and which therefore has to be done by the legislature and the executive.
I think it's been a fantastic answer. We really appreciate it. I don't know if anyone else has any questions that you'd like to, or any further ideas. It's Rodrigo.
Well, thank you very much for the history lesson regarding Reagan and Edwin Meese. We really have enjoyed the book. I have learned a lot, and it was very, very interesting to see the history and the data regarding the use of the term originalism. And you are able to learn that before Edwin Meese, there was no doctrine such as originalism. So it is very, very interesting, because now you learn, at least in some schools, some law schools, that this is actually a doctrine or a school of thought or a way to interpret a statute, the Constitution. And it was fascinating to learn that this is thanks to one Attorney General whose intention was to include this in the study of law. So I just wanted to comment that I learned a lot through your book, and it was very, very interesting that you can find the exact origin of such a doctrine like originalism.
Well, thank you very much. It's a great story, and it's a great tribute to Ed Meese that he was able to do that. And also, he was aided in doing it by Justice Antonin Scalia and by Judge Robert H. Bork and by others as well. But I'm so glad that discussion of originalism is now appearing in Guatemala, and I'm really honored to be invited to speak to you. And I hope someday I can come and pay you a visit in person. I would love to. I would love to go to Guatemala. I've never been before, and my schedule is very hectic, and it's hard to fit things in. But I'm very admiring of the job you're doing. And I should tell you, when we started the Federalist Society in the United States in the fall of 1981 and the spring of 1982, we only had 5 members. And today, the Federalist Society has 70,000 members, and our budget for our first conference was $20,000. And today, our annual budget is $32 million. So we started out as just a group of 5 people having lunch together, but we kept talking and talking and being missionaries, really trying to convert people. And with the help of people like Ed Meese and Robert Bork and Antonin Scalia, we were able to build a great movement. So even if you're small and getting started, you can go on to have a huge impact. And that's been the story of my life, really. I remember after President Reagan was elected in a landslide, I went to a law school class of 90 students, and everyone was grief-stricken that this conservative had been elected president, because Yale Law School was very left-wing at the time. And about 40 minutes into the class, the teacher asked, "Is there anyone in this class who even voted for Ronald Reagan?" And out of 90 students, there were only two of us, me and one other person who raised their hand. And I immediately thought to myself, I want to have lunch with that other person. And it was out of that lunch and other lunches like it that we got first 5 people and then 10 people and now 60 people in the Yale Law School Federalist chapter and 70,000 members nationwide. So even if you're small and getting started now, you may have very great moments of success ahead of you.
Yes, thank you. We have great hopes for our group as well. Yes.
Hello, yes, I have a question, and it is with respect with the originalist interpretation. I was wondering if you consider it somewhat limited, and if the limits of the originalist interpretation are inherent to the faculty the judge has or doesn't have, or on the contrary, if, for example, sometimes that method of interpretation can be limited. So what I'm trying to get at is that maybe it is different to interpret through originalism. And if it isn't, well, is that inherently something that the judge shouldn't do by nature if he cannot interpret it through originalism? I don't know if my question makes sense.
Yes, I think your question does make sense. I think there are constitutional questions that come up that are very difficult to answer, even using originalism. So, for example, the United States has a separation of powers. We elect a Congress separately and we elect a president separately. And Congress has legislative power and the president has executive power. And it's clear that Congress doesn't have the power to pass laws delegating its legislative power to the president. And yet Congress passes laws doing that all the time. But it's very difficult for the Supreme Court, except in extreme cases, to say that Congress has delegated legislative power to the president, because oftentimes Congress needs to give the president fairly broad power. So originalism is a theory of interpretation, and it works well for some clauses. It's harder to apply for some other clauses. I think the answer is that when you can't interpret a clause according to its original meaning and judges can't apply it, then the courts can't take action on the basis of that clause. They can't just make up a meaning that they wished the clause had, and because their judges, rule for that outcome, that would be, I think, a violation of originalism. So I don't know if that fully answers your question, but I do think there are some clauses which are easier to find the original meaning of than other clauses. I mean, for example, the U.S. Constitution requires that the president be 35 years old. That's easy to interpret and to enforce. You're either 35 years old or you're not. But when the Constitution gives the Congress legislative power and the president executive power, and the president and Congress delegates to the president some emergency power, it may be very difficult to figure out whether it's an unconstitutional delegation of power. And I think the answer, if you're an originalist judge, is that if you can't figure out whether something is a violation of a constitutional clause, you just can't enforce the clause, because the judge's authority to act comes from the ability to interpret the text and apply the text. And so if you can't interpret and apply the text, then the judges are supposed to stay silent and not come up with some ruling of their own. So going back to the question about, you mentioned Guatemala has entitlements to affirmative rights in its constitution, and I don't know what all those entitlements are, but my guess is that many of them might be ones that judges simply can't enforce given originalism.
Professor Calabresi, I am very honored to meet you here in the Francisco Marroquin University. We have very good professors also who taught us about the different legal systems, the different schools of thinking. But your book is very well written and very good supported, but a lot of lectures. The main apport that the book gave me was all the readings that makes me go and search for it. We have the privilege to study Professor Guido Calabresi here in the university. He's a well-respected professor here. And your book just support the legal prestige that the Calabresi members of the family have, from my point of view. So the another great apport of your book to my life is that my way of think about the law changed. Why? Because I am very respectful of the system of the stare decisis, but your book told me that the main allegiance to the law is to the Constitution. So it's not to the stare decisis. So I think that was the biggest change in my mind. So nice to meet you. I am very honored to meet you, Professor Calabresi.
Well, I'm very honored to meet you and very honored to be compared to my wonderful uncle, Guido Calabresi. He inspired me to go into law teaching, and we remain very close. And he will be turning 93 years old on October 18th in a couple of days. And he continues to teach and judge and hear cases and to be very active. And we remain very, very close to each other. He's a wonderful, wonderful man. So thank you very much for the comments and for the comparison. And it's a real pleasure to meet you.
Thank you so much. Would you like comment? We also like to know more about the Federalist Society and the spaces, academic spaces that can be formed through that. Obviously, you had a foundation, literal foundational involvement in this. What sort of ideas could you give us to carry on doing our work better?
Well, one of the Federalist Society started in the law schools. And it started in 1981 and 82 in Yale Law School and at the University of Chicago Law School. And we then decided to hold a national conference, and we invited any students interested in conservative legal ideas or interested in originalism to come to that conference. And there were only 5 to 10 of us in the Yale Federalist chapter when we held that first conference, but 180 people from all over the country came, and they asked how to found chapters at their own schools. And so we put together a manual on how to found a chapter. And today we have chapters at all 200 American law schools. So, one thing you can do is put your chapter in contact with like-minded students at other law schools in your country and work toward having a national conference. And if you do that, you'll probably come to the attention of prominent legal leaders like Attorney General Ed Meese. So that might be, one way of pursuing this. And the Federalist Society and its support of the Law and Society conferences can help provide funding to host such events and to encourage the formation of chapters at other law schools as well.
I saw you, Professor Calabresi, at the National Law Convention last November, and you signed me your book. My question is basically about the importance of the history, because you mentioned that in your lecture and in your book is elaborate, because it's impossible to interpret a constitution without history, without context, and what do you think about the importance of history? Because, for example, a prestigious historian, Gordon Wood, and a prestigious jurist, Akil Amar, wrote book reviews about your work, but both are jurists and historians. I think we need more in Latin America, for example, relationship between laws and historians. And what do you think about the relationship between historians and jurists about the importance of the Constitution, for example?
Yeah. Well, I do think originalism requires some knowledge of history, and words on paper only mean something in an historical context. But I also think there's a difference between the job of an originalist lawyer and the job of an historian. I think, as Justice Scalia used to argue, an originalist lawyer needs to determine the meaning of the text of the Constitution, or of a clause in the Constitution, or of a word. And sometimes that can be done by looking things up in authoritative dictionaries that were widely used at the time when the constitutional provision was written. I don't think one needs to know the whole history of a country to be an originalist judge. I think one needs to know the history of particular clauses and the meaning of particular words. And so the job of an originalist is narrower than that of an historian. Now, there's some historians like Gordon Wood who are very interested in law and originalism, and there's some law professors like me and Akil Amar who are very interested in history, and so there inevitably is a blending of the two. But there is this fundamentally different idea. Ultimately, what I would say about this is that I think we are bound today by the laws that are in the Constitution, but not by the unenacted opinions that people may have had when the Constitution was written. So the 14th Amendment to the U.S. Constitution, as we understand it today, applies to discrimination against women, even though it was not understood that way in the 1860s when the 14th Amendment was passed. And so there is a tension in that, as Judge Bork once said, important values have to be applied. Fundamental values have to be applied to change circumstances in the world today, and that makes judging a little bit different from doing history. Yeah. I mean, our Constitution, for example, protects freedom of speech and of the press. And if you read that literally, you would say, well, the only thing that's protected are spoken words and books produced with a printing press. Mm-hmm. But Justice Scalia said they used the words freedom of speech and of the press as a synonym for freedom of expression. And so he applied the First Amendment to television, radio, movies, the internet, in all sorts of things that aren't strictly speaking vocal utterances and speeches and that aren't the product of a printing press. I think that's a completely legitimate move to make. I think an illegitimate move to make is to say that because the Constitution protects against unreasonable searches and seizures, therefore it allows women a right to have an abortion up until 24 weeks of pregnancy. That's stretching matters too far. So, judging is not a science, it's an art, and it requires some judgment to figure out how to apply a permanent text to a changing world. The exact sentence that Bork used to describe this phenomenon was, quote, "The world changes in which unchanging legal texts find their application." And that's just undeniably true. For example, our federal government has the power to regulate any commerce or trade across state boundary lines. And today we have 50 states, not 13. And so there are exponentially more state boundary line crossings than there used to be, which makes our federal government more powerful. And then on top of that, in the last 236 years, we've invented the internet and airplanes and car travel and rail travel and steamships. And so there are many more state line crossings than there would have been even if we still had only 13 states and not 50. So yes, I think the meaning of the text is fixed, but we do have to remember that the world changes in which an unchanging legal text finds its application. That's not a license to just make up new rights, but it is authorization to apply the text to new and different circumstances. If that is, I hope my answer is making sense.
It is very, very much so. I don't know if there's any question. One last question, which is quite obvious, would be how can we apply this concept of originalism to the international in an international sense? Is it a possibility? Can we talk about originalism internationally? I think it's very, very important, given that we are a Law and Liberty Circle, which is an international offspring of the of the Federalist Society, or not, well, an association, that this can also be exported. I mean, it's such a great idea. This is why I'm calling it the Calabresi Revolution, because I think it's beyond Meese, and your book goes beyond the borders of the United States. We are sitting here because of you, basically. So I think it can, and I was wondering if you have any thoughts on this.
Well, thank you. I think it can spread around the world, and we've made a conscious effort for 19 years now to support law and liberty circles in countries all over the world. And we have very active law and liberty circles, as you probably know, in a number of other countries around the world. There's a very active circle in Paris, in London, in Tel Aviv, in Jerusalem, in Vienna, in Berlin. And so far, I think we have been slower in spreading to Latin America, but I hope that changes and that we are able to form more of a presence in Latin America. But ultimately, we live in a world where what happens in one corner of the world just influences and affects what happens in another corner. So for originalism to really triumph, it would have to triumph worldwide. It couldn't just triumph in the United States, which makes the work you're doing in Guatemala all that much more important and causes me to wish you great, great success in your efforts to build your chapter and maybe inspire students at other law schools to form chapters too.
Thank you so much, Professor. An applause.